Welcome to Trademark News. I'm Hayley Tarr. In Trademark News this week, we have an application for Lo Secco Prosecco for alcoholic beverages in Class 33, which would include sparkling wines such as Prosecco. The reason why this is interesting is because in around 2013, the European Union recognised Prosecco as a geographic indicator for wine produced in the region of northern Italy. The grape, at that time previously known as Prosecco, was renamed in Italy and the European Union to Glera, so that Glera was the grape and Prosecco was the name of the wine that originated from the northern Italian area and could be recognised as a geographic indicator. In 2013, so around that same time that it was recognised as a geographic indicator in Italy, the European Union then lobbied for the Australian government to recognise it here as well as a geographic indicator. So a trademark application was filed by the European Commission trying to register Prosecco as a geographic indicator in Australia. That application was denied by the Australian Trademarks Office because they found substantial evidence that Prosecco was the name of a variety of grape, which it was, even as recognised in the European Union itself up until 2013 when they renamed that grape to Glera. So based on that evidence, Prosecco was rejected as a geographic indicator in Australia. Since then, both the Australian government and the European Union have continued to push their agenda in relation to this issue of Prosecco as a geographic indicator. The reason being that there is so much money at stake, not only for Prosecco, but for all geographic indicators, because it then maintains a monopoly over a certain product for a certain region, and therefore all export of that product must come from that region, and all income generated from that product goes back into that region. So as at around 2020, Australia was making roughly $60 million from exporting Prosecco wine to other countries. This is expected to greatly increase, and by the next 7 years or so, by 2030, it's expected that Australia will be making around $500 million a year by exporting Prosecco. So there's a decent amount of money at stake here. And as a consequence, in 2020, the Australian government announced that it would allocate $100,000 research grant to Monash University for them to build a case against the geographic claim for Prosecco. And then equally, the EU are still pushing. So in around the same time, 2020, they pushed to have Prosecco listed on a list of more than 1,500 geographic indicators that was to be included in a $100 billion bilateral trade agreement between Australia and the European Union. So as part of Australia's push, just last year in 2022, an Australian organisation, the Australian Grape and Wine Inc., challenged a Italian company, and I'm not even going to try and pronounce it, but it was related to the origination and control of Prosecco. It went all the way to the High Court in Singapore, and eventually the Australian company, or the Australian body, was found to succeed in their application in the High Court. So that the Singapore High Court held that Prosecco objectively referred to a plant variety and could originate from various geographic locations. Hence, if Prosecco was recognised as a geographic indicator in Singapore, this would be misleading as to the true origin of the product. This means that Australia effectively preserves Singapore as an export market for Australian grown and produced Prosecco. That's the law as it stands today. That's not to say that the European government isn't going to continue to lobby to have Prosecco and other geographic indicators listed as geographic indicators in Australia, and thus to stop the production and export of Prosecco from Australia. So companies such as the company filing the trademark application for Lo Secco Prosecco may get the application through to registration as the law stands today, but they should factor in that their mark will always be vulnerable to future changes to the law if the European Union, for example, successfully lobbies to have a mark listed as a geographic indicator in Australia. So that would amount to a potential loss of rights in their registration, and also a loss of a huge amount of goodwill that's been generated through use of that mark. In some cases, trademark owners might be careful to exclude possible geographic indicators from the mark itself, just registering, for example, Lo Secco, because then if Prosecco is then prohibited for use in the future, they could still use Lo Secco in relation to sparkling wines, just not having that Prosecco portion, and thus not having to reapply for registration of a new mark without Prosecco in it. So forward thinking is an important aspect to trademark registration. Another big thing that's come about in trademark news this week is that there were 36 new trademark applications in the name of Canatrek. Now, to put this into perspective, Ainsworth Game Technologies is one of Australia's most prolific filers. It has over 726 pending and registered marks on the database at the moment, but there have been over 1,200 or so marks filed over time. It's just that some of those have been deregistered if they weren't renewed, have been abandoned. So Ainsworth Game Technology is a gaming machine business, very established, very prolific filer. It has filed 6 new trademark applications this week, 1/6 of the number of applications filed in the name of Canatrek this week. Other big organisations like LSKD, one of Australia's fastest growing sportswear brands, have filed 6 trademark applications this week. The Hello Cup Holdings Company, which seems to be a newly emerging menstrual products company, has filed 6 because they're new. They're starting to build up their brand database. Each of those companies has filed 6. Collectively, that's 18. That is still only half of the number of trademarks that have been filed by Canatrek. 36 marks in 1 week is a huge number of applications. Canatrek is a medicinal marijuana company. So they are obviously banking on the fact that Australia is going to continue to legalise medicinal marijuana, and internationally also that industry will be legalised and will therefore grow so that we can start exporting medicinal cannabis overseas. Obviously, we have a good environment to grow it here. Again, it's a risk, like with the geographic indicator marks. If the law doesn't ease up and medicinal marijuana is not permitted, then a lot of these Canatrek marks might have been filed in vain. But it seems at this point in time that they've made a fairly safe bet. In other news, just sort of more general things to finish off, we have seen a number of purely descriptive marks filed this week. Brisbane Distillery, Main Beach Lawyers, AccuNeedling, Solicitors.law, and Illawarra Market. And in addition, we've seen a number of marks filed without a legal entity nominated as the owner. So there was one application, for example, in the name of This Is Magnetic Island. The message still doesn't seem to be getting through. The trademarks need to be registered in the name of a legal entity that's a human being or a corporation. So it should have Proprietary Limited or Inc. or Limited or LLC, something at the end of it. And that trademarks that are purely descriptive don't function as badges of origin. And so unless there's extensive amount of use, things like Illawarra Market that are geographically descriptive, or AccuNeedling, which is the name of the service that you're providing, are simply not going to get through. And something light to finish off on, some entertaining marks were entered on the register this week. We've got the Whiny Cow, which was registered for restaurant services, and Where Babies Were Made was registered for human fertility services. And lastly, My Parents Might Be Martians was registered for games. I'm sure my kids would like that mark. That's all for Trademark News this week. I'm Hayley Tarr. I'll see you next time.